My name is David Gallo. I'm the director of the AIFC Academy of Law. We'd like to welcome all of you who have joined us today from literally across the globe for the next installment of the Academy of Law webinar series. First and foremost, we hope you all are well and safe. We very much respect your joining us for these ongoing learning and development programs and moving the interests of your law firms and your companies forward during these rather unprecedented times. So thanks so much. We're very, very pleased to have you join us. We look forward to seeing much more of you in the future. We're in the process of finalizing our 12-month plan. We have a lot of very exciting learning and development activities coming up. Well, today we have a very special event on an incredibly important topic of anti-money laundering and combating financing of terrorism, especially with reference to the AIFC regulations. And at this point, I'm going to go ahead and turn over the floor to my friend and colleague who will introduce today's esteemed speakers. So first, let's start with Professor Dr. Alexander van der Put, who is the chairman of the AIFC Academy of Law Academic Council. He's the Chief Strategy Officer of the AIFC and the Chairman of Corporate Governance and Stewardship. He's an academician also at IE Business School. Professor van der Put is which is one of Europe's leading business schools. Professor van der Put is the Professor of Strategy and Strategic Foresight. So with that, Alexander, thank you.
Good afternoon, everybody, and David, thank you very much for the very kind introduction. As David mentioned, this is a very important topic for the AIFC and its development, and also, I would argue, therefore, for the development of the country as a whole. Just to remind our audience what our mission is. Our mission at the AIFC, and that includes all the bodies and organizations, is to contribute to sustainable economic development of Kazakhstan and the region by fostering innovative financial products and services. Why is it our mission? Well, we have to build trust in the external environment, also in the internal environment, in order to attract foreign direct investment. And this is the key reason why anti-money laundering, but also countering financial terrorism, is going to be so critical in order to build that trust. As you all know, building trust is difficult. Losing it can happen overnight. So I'm very pleased to introduce two of our colleagues. They both work for AIFSA, and AIFSA is the Astana Financial Services Authority. They're also both experts in the aforementioned fields of AML and CFT, so countering financial terrorism, for those that do not know the acronym. So the first speaker will be Yerkegali Yedenbayev, and Yerkegali, he's a director with AIFSA. He has extensive experience in the field, especially of AML, built up at very senior position levels at the National Bank of Kazakhstan, of course, and also on the regulation and supervision of financial markets and financial organizations. So Yerkegali will speak first. Later on, his colleague Dulat Akkassov, he's an associate with AIFSA. He will take over. Yerkegali will then also hand over to Dulat. Similar to Yerkegali, Dulat has extensive experience in both AML and CFT. But currently they're both employed with AIFSA. We're very happy to have them work with our own regulator in order to drive this important topic forward. I know they will enlighten you with their insights. So now I hand over to Yerkegali, and I will be on mute, but I will be listening in on this important topic. Yerkegali, the floor is yours, and we're all excited for you to facilitate this topic. Thank you.
Thank you, Professor, for the kind introduction. At the beginning, I'd like to thank AIFC Academy of Law for the opportunity to introduce to the legal community some aspects of AIFSA mandate. And I want to thank the audience for the interest in AIFC activities. I'm presenting only one division of AIFC, which is financial conduct. Our division is responsible for the three major spheres in the supervision. First of them is conduct of business supervision based on the requirements of AIFC conduct of business rules. As you might know, conduct of business is a relatively new concept in financial regulation and covers almost all risks, excluding financial risks. The second sphere of our focus is consumer protection. The consumer protection is crucial to AIFC, especially now when AIFC has no safety net framework. The third sphere of our focus is AMLCFT, regulation and supervision, which is very important for AIFC, taking into account the initial stage of development of our financial center and the high level of attention of international community to the AMLCFT issues. Now let me introduce my colleague, Mr. Dulat Akkassov, who is a major driving force in AIFC, AMLCFT regulation and supervision. Dulat, the floor is yours.
Thank you, dear colleagues, for kind introduction. Good afternoon, dear participants. Welcome to our AMLCFT webinar. My name is Dulat Akkassov, and I am Associate at Financial Conduct Division, and I am responsible for AMLCFT issues. Next slide, Jeff, please. This is the outline of our presentation. At first, it's introduction. I will explain about the global AMLCFT network. Then I will explain the AMLCFT framework in AIFC, including explanation of the main requirements of the AML rules and AML guidance. The next one is features of the AMLCFT legislation of Kazakhstan, which include explanation of the AMLCFT law of Kazakhstan, last key amendments to AMLCFT law, then a resolution of governments where define the special requirements in case of submission of information to FIU. And the last one, it's an order of the Minister of Finance where define the special requirements in case of customer due diligence. And the last one, it will be this question and answer section. Next slide, please. In 1989, an intergovernmental body, the Financial Action Task Force, was established, and AMLCFT Global Network had started its activities. FATF 40+9 recommendations were issued in 1990, then revised in 1996 and 2001 and 2003. In 2001, I want to highlight that 9 special recommendations were added in case of financing of terrorism. And the most recently amendments were in 2012, and the last amendments into the FATF recommendations were added in 2019. Nine special recommendations were included during the last amendments, and FATF recommendations cover 3 aspects. At first, it's combating of money laundering, and then terrorist financing, and combating of financing of proliferation weapons of mass destruction. The next one, it's a Eurasian group on combating money laundering and terrorist financing. It's a FATF-style regional body which assists state members in implementing of 40 recommendations of FATF. And in this case, Kazakhstan is a member state of EAG. AIFC, as a jurisdiction with a special legal regime, implemented the requirements of FATF applicable to the relevant AIFC participants. Also, AIFC, as a regulatory body, monitors compliance with FATF requirements by the relevant AIFC participants and takes all necessary measures to improve the AMLCFT system in AIFC. The next stage is AIFC jointly with FIU will take part in the preparation process to the second round of EAG mutual evaluation of Kazakhstan in 2021 and 2022. Also, I want to inform that in the framework of the first round of mutual evaluation, Kazakhstan was assessed in 2010. Next slide, please. Here, in addition, we can recommend for financial institutions and DNFP these FATF documents on risk-based approach as an additional tool in the field of AMLCFT. You can find these documents on our website and also on the website of FATF. These documents highlight the need for a sound assessment of money laundering and terrorist financing risks that financial institutions and DNFP face so that the policies, procedures, and initial and ongoing customer due diligence measures can mitigate these risks. This risk-based approach is central to the effective implementation of the FATF recommendations to fight money laundering and terrorist financing. These documents aim to support financial institutions and DNFP in the design of effective measures to manage the money laundering and terrorist financing risks when establishing or maintaining business relationships. In particular, it explains the obligation for financial institutions and DNFP to identify and verify beneficial ownership information and provides examples of simplified standard and enhanced CDD measures. Next slide, please. Here you can see the list of documents in case of AMLCFT framework in AIFC. At first is AIFC AML rules. On the next slides I will explain in details. Then AML guidance, also I will explain. Then the joint order, which defines the conditions for cooperation between AIFC and FIU in the field of AMLCFT. The next one is a list of predicate offenses relating to the money laundering and terrorist financing. AIFC adopts the list of predicate offenses with references to the appropriate articles of Criminal Code of the Republic of Kazakhstan based on the designated categories of offense defined in the FATF recommendations. The next one is a list of typology research reports relating to the money laundering and terrorist financing. The typology reports on money laundering and terrorist financing methods can assist all AML-CFT stakeholders to better understand the nature of existing and emerging money laundering and terrorist financing threats and pursue effective strategies to address those threats. The typology research reports are publicly available on the website of FATF and FATF-style regional bodies. Also, all the links you can find on the AIFC website. These documents provide the samples of money laundering and terrorist financing methods and trends, explanation of measures on combating money laundering, and general description of typologies and case studies. These samples of typology reports will assist for financial institutions and non-financial business and professions in identifying, assessing, and understanding of money laundering and terrorist financing risks that they are exposed to, and as well as to detect and combat of money laundering and terrorist financing. The next one is the AIFC notice on the requirements to the AML training courses for the relevant persons and recognized AML training centers. In this notice, we indicate minimum requirements for AML training courses, and you can find the list of organizations which met with these requirements. The last one is the AIFC notice on class waiver and modification for the representative offices, which include a non-application of the requirements of AIFC AML rules. In this notice, AIFC provides for representative offices a class waiver on the requirements of the general rules and representative office rules, and also a class modification on the requirements of the AIFC AML rules. In this case, we understand that the main activity of the representative offices is marketing activity, which not covered by the requirements of the FATF recommendations. Next slide, please. The features of the AMLCFT framework in AIFC. AMLCFT framework applicable to the 27 regulated activities and 8 market activities, which cover capital markets, asset management, private banking, Islamic finance, financial technologies, and trust activities. For example, trust activities are not available in Kazakhstan, but in AIFC jurisdiction it is possible, and of course it is a regulated activity which falls under the requirements of the AIFC AML rules. The next one, it's a simplified supervisory requirements for the representative offices. In this case, AML rules, as I mentioned before, are not applicable to the representative offices. The next one is AML guidance with minimum requirements of the AMLCFT law of Kazakhstan and AIFC AML rules applicable to all relevant AIFC participants. It means financial institutions and DNFP. And the next one is AFSA may provide a temporary waiver or modification of one or more elements of AIFC AML rules in order to simplify the supervisory requirements on the initial stage of AIFC participants' activities. In this case, for example, AIFC participant may apply for a waiver or modification of one or more elements of AIFC AML rules, and AFSA will consider this request and sample of waivers and modifications you may find on our website in the section of Register of Waivers. Next slide, please. Let's start with the introduction of the AIFC AML rules. Our purpose of AML rules is have been designed to provide a single reference point for all persons and entities. And AML rules are applicable to authorized firms, authorized market institutions, DNFP, and registered auditors who are supervised by AFSA for AMLCFT purposes. Next slide, please. This is a definition of DNFP. In AIFC glossary, you can find who falls under this definition. At first, it's the real estate developers, dealer in precious metals and precious stones, then law firms, notary firms, and other independent legal business, then accounting firms, audit firms, then company service providers, and single family office. Next slide, please. Here you can see the general requirements of the AML rules. At first, it's a business risk assessment that relevant persons have obligation to conduct business risk assessment. In this case, a relevant person must take appropriate steps to identify and assess the risks of money laundering and terrorist financing to which business is exposed, and must establish and maintain policies, controls, and procedures to mitigate and manage the risks identified. The risk factors can be a customer, country, or geographic areas in which a relevant person operates, products and services, transactions, delivery mechanisms, channels and partners, and development of new products and technologies. The next requirement is to adopt internal policies, controls, and procedures. About the structure of AML policy, controls, and procedures, I will explain on the next slide. The next one is a customer risk assessment. A relevant person must undertake a risk-based assessment of every customer and assign the customer a risk rating proportionate to the customer's money laundering and terrorist financing risks identified. The next obligation is to conduct customer risk assessment for all customers, then which can include identification of the politically exposed persons and beneficial owners. In this case, we understand that a relevant person must identify all its customers and use all available tools and procedures in case of identification of politically exposed persons and it's his or her family members. These requirements you can find in AML rules and AML guidance. In case of beneficial owner, of course, a relevant person must identify all beneficial owners, all available stakeholders. Also, a relevant person must check all its customers and identify not only the shareholders, of course, try to identify all available persons who can be involved in this business. In case of prohibition on relationships with shell banks, a relevant person must not establish or maintain a business relationships with shell banks because it is a high risk activity and of course can be prohibited. The next one is customer due diligence. The first requirement is the identification and verification process of CDD. In this case, a relevant person should conduct CDD procedures in compliance with risk rating and identify the type of due diligence. And if, for example, the results of customer and business risk assessments show a high level of risks, it should be conducted enhanced due diligence with additional procedures and measures for mitigating and managing these high risks. The next one is a simplified due diligence. If the results of the customer and business risk assessment show a low level, it should be simplified due diligence where a relevant person undertakes simplified measures of CDD. The next one is ongoing CDD, which include monitoring of transactions undertaken during the course of its customer relationship. Then particular attention to any complex or unusual large transactions. Then background checks and purpose of the transactions, and periodically review the adequacy of the CDD information. The next one is check sanction lists. A relevant person must review its customers, their business and transactions against the FATF and United Nations Security Council sanction lists and against also sanction lists of Kazakhstan. For example, the sanction lists of UN you can find on the website of UN and also a website of FIU. In addition, FIU published its own sanction lists in case of the financing of terrorism. This list defined the conditions of the financing of terrorism in case of natural persons and legal persons, legal entities. The next one is the sanction systems and controls. A relevant person must establish and maintain effective systems and controls to ensure that on an ongoing basis it is properly informed as to and takes reasonable measures to comply with relevant resolutions or sanctions issued by the United Nations and Kazakhstan. A relevant person must freeze without delay and without prior notice the funds or other assets of designated persons and entities pursuant to relevant resolutions or sanctions of UN or Kazakhstan. Also, here relevant persons can check its customers for the other lists, for example, not only the FATF, UN, or Kazakhstan. A relevant person may use other lists, for example, Treasury of United States of America, then Basel Committee or others. Of course, it will be useful for the relevant persons to identify its customers. The next one is a notification obligation. A relevant person must report to the FIU of Kazakhstan. It is a Committee on Financial Monitoring of the Ministry of Finance about any assets frozen or actions taken in compliance with the prohibition requirements of the relevant resolutions or sanctions issued by the UN or Kazakhstan. Next slide, please. As I mentioned before, here you can see the minimum requirements to the AML's policies, controls, and procedures of the relevant persons. AML policies, controls, procedures. In this case, a relevant person should able to demonstrate the evidence of compliance with the requirement of AML rules, AML guidance, and AMLCFT law of Kazakhstan. And this is a minimum structure of the AML policy as a minimum requirements. Here it's a risk-based approach, which should include customer and business risk assessment, then customer due diligence with the identification of the simplified, standard, and enhanced due diligence, including the identification of the politically exposed persons, ultimate beneficial owners, and prohibition of in case of shell banks. Then reliance on the third party and outsourcing of CDD elements. For example, for a relevant person, it's available to rely on the third-party information in case of customer due diligence. One or more elements a relevant person can rely. And in case of outsourcing of CDD elements, of course, we require that in AML policies, controls, and procedures of a relevant person should be established the conditions for the outsourcing of CDD elements, all the risks, of course, because during the outsourcing of CDD procedures, a relevant person may have risks. And in this case, in order to mitigate and manage these risks, a relevant person should at first assess its business and customer risks, and then rely on the or outsource all the CDD elements. The next one is correspondent banking and wire transfers. Of course, this requirements applicable for authorized persons only. The next one is the sanctions. In case of sanctions, a relevant person must establish in its AML policies all the procedures of checking sanction lists. The next one is money laundering reporting officer. Here you can see the requirements taken from the AML rules and AML guidance. At first, it's an appointment of MLRO. We have the minimum requirements to the appointment of MLRO. At first, it's at least 2 years experience for MLRO in the field of AMLCFT. And in case of absence of relevant experience, MLRO should have AML training certificate, which confirms that MLRO understand the the requirements of the AMLCFT system. The next one is obligations to cooperate with AIFC, FIU, and relevant state authorities of the Republic of Kazakhstan. Of course, a relevant person should cooperate with regulatory body in case of at first suspicious transaction reports, threshold transactions, then in case of regulations or maybe some changes or structuring the AMLCFT policies. In case of some qualities of MLRO, of course, you can find the requirements in AMLCFT rules, where defined the special qualities of MLRO and describe the responsibilities of MLRO. In case of outsourcing of MLRO functions, this requirement is applicable for relevant persons who receive the outsourcing of MLRO functions in case of when relevant persons cannot appoint MLRO due to the different reasons. And in this case, we require that in AML policies, controls, and procedures, a relevant person should establish all the procedures of the outsourcing of MLRO functions, and of course indicate all the risks and conditions of this outsourcing. In case of reporting to AIFC and FIU, MLRO should provide on annual basis annual AML return to AIFC. You can find the form on our website. And in case of reporting to FIU, a relevant person should provide all information in case of suspicious activities or threshold transactions. Then the requirements of training and awareness. MLRO should provide training and awareness for employees of the relevant person and make records and keep all the information about the training and awareness of other employees. And of course, in this case, senior management should be also involved in this process. In case of groups, branch, and subsidiaries, of course, it's also applicable in case when the relevant person has branches or subsidiaries, or it is a corporate group company. The next one is the record keeping. Also, it is an important requirement where MLRO should fix all the information about CDD results, about the suspicious transaction, threshold transactions, about the information submitted to FIU, about the communication with AFSA. And all these records will be checked during the off-site monitoring and on-site inspection conducted by the AFSA. The next one is data protection. Of course, we understand that MLRO should create all the conditions for protecting information in case of customers, transactions, in case of identification, verification, and CDD measures. And the last one, it's an audit requirement. Of course, it is applicable for authorized persons, but sometimes we understand that the audit cannot be conducted because most of the AIFC participants are on the initial stage of business activities. And of course, during the submitting of annual AML returns, relevant persons must provide all the information in case of audit. It can be internal audit, of course, if the relevant person has a special division which conduct internal audit, and also the records and requirements of the audit firm which conduct the audit for the relevant person. Next slide, please. Here you can see our recommendations for the relevant persons, and these recommendations can help to establish of business activities for relevant persons in case of AMLCFT. Of course, it's very important when a relevant person gather information about its customers. We require to gather information about every customer. It doesn't matter it's with high risk or low risk or middle risk. All information should be available for the on-site inspection. And in this case, the next one is analysis of received information, then identification and assess of the risks of money laundering and terrorist financing. All these procedures are important, and in case of off-site monitoring or on-site inspection, we will check all these procedures, and all these procedures should be implemented in AML policies, controls, and procedures. The next one, please. Next slide. Now it is AML guidance. Let me introduce in details. On May 21, 2020, AFSA approved the guidance. We call it AML guidance. This AML guidance was developed according to the paragraph 3.2 of the Article 11 of AMLCFT law of Kazakhstan. Then you can find the requirement in case of AML guidance in our AML rules. Then it was the requirement of the joint order. And AML guidance was adopted in order to implement the basic requirements of AMLCFT law. Thereby, AML guidance covers the relevant aspects of the FATF recommendations and AML rules. The structure of the guidance is designed based on the template approved by the Ministry of Finance in compliance with the requirement of the AML law of Kazakhstan. Next slide, please. This is a structure of AML guidance. The AML guidance expands and discloses the scope of regulations of AMLCFT legislation of Kazakhstan, which include establishing and maintaining the AML policies, controls, and procedures, then identification of money laundering and terrorist financing risks, and managing the risks identified, including the business and customer risks. The next, monitoring and assessment of customers' transactions and activities, including politically exposed persons and ultimate beneficial owner. The next one is procedures of the customer due diligence, enhanced due diligence, and simplified due diligence. And the last one is obtaining relevant AML training for employees. In case of AML guidance, I want to highlight that these documents in these documents define the requirements of the AMLCFT law and AML rules in details. Next slide, please. Here you can see the list of legal acts of the Republic of Kazakhstan in the field of AMLCFT. At first, it's a law of the Republic of Kazakhstan. Then the criminal code, we indicated two articles. Article 218, it's about the money laundering. The next article, it's about the financing of terrorism. Based on the requirements of the FATF recommendations, the Republic of Kazakhstan criminalized both offenses. And in addition, based on the requirements of the conventions, international conventions, also the money laundering and money laundering and terrorist financing was included in the criminal code and have the several predicate offenses which can be which can relate it to the money laundering or terrorist financing. The next one is the resolution of the government on approval of the rules for provision of the reporting of data and information by the relevant persons. Here you can find the requirements in case of providing information to FIU and special requirements in case what kind of information should be submitted to FIU. The next one, it's order of the Ministry of Finance of the list of documents required for the customer due diligence. About these two documents, I will explain in details on the next slides. And the next one, it's order about the list of offshore zones for the purpose of AMLCFT. And the last one, it's a requirement to the monitoring to the AML training and education of employees. Next slide, please. In August 2009, the AMLCFT law of Kazakhstan was adopted. From 2010 and 2020, in order to improve the legislation of Kazakhstan in the field of AMLCFT, the relevant law of Kazakhstan has updated 34 times. The amendments to the AMLCFT law last made on 13th of May 2020, and these amendments will come into force on November 14, 2020. The amendments were adopted in the framework of preparation process to the second round EAG major evaluation of Kazakhstan in 21 and 22, and also AFSA identified around 50 new norms which extend the existing norms and relate to the AIFC participants subject to the AMLCFT supervision according to the AML rules. In this case, detailed information you can find on our website about the amendments. Next slide, please. The AMLCFT law defines legal basis of anti-money laundering and terrorist financing, contracting of terrorist financing, legal relations of subject of financial monitoring, authorized body, and other state bodies of the Republic of Kazakhstan in the sphere of AMLCFT. Also, AMLCFT law has the following directions. At first, it's a list of financial monitoring entities and their responsibilities. then threshold requirements for the threshold transactions and types and amounts. The next one is the general requirements for CDD, including identification of the politically exposed persons, beneficial owners, and foreign financial organizations. And the last one, it's the powers and responsibilities of FIU. Next slide, please. Here you can see the key amendments related to the AIFC participants, which were amended in AMLCFT law in May 2020. Expansion of the scope of regulated sectors to new categories of financial monitoring entities you can find in Article 3. It means that the appropriate requirements of the AMLCFT law will apply to the relevant AIFC participants. Therefore, AFSA will adopt the list of relevant activities of the AIFC participants for the AML purposes in consultation with the Ministry of Finance, which will be in compliance with the FATF recommendations. The next amendment is in Article 11, where AFSA should revise the relevant activities for the purposes of the relevant AML guidance. And AFSA will adopt the relevant amendments to the AML guidance in consultation with the Ministry of Finance based on the new amendments to AML law. And the last one, it's requirements will be adopted by AFSA in consultation with the Ministry of Finance in case of the establishing customer due diligence, in case of the non-face-to-face business relationships. Next slide, please. Next slide, please. Thank you. Here you can see the description of the resolution of government and order of the Ministry of Finance. Resolution of government determines the methods and procedures of providing information and data for FIU by the relevant persons. There are defined the conditions, requirements, and all the information about the suspicious transaction reports and threshold transaction reports. The next one is order, which determines the list of documents required from the individuals and legal entities and their representatives in case of customer due diligence. In this case, relevant persons may guide it by this order, where indicated minimum requirements to the legal entities and individuals in case of identification and verification in order to conduct the customer due diligence. Next slide. Okay, thank you. We can start our question and answer section.
Okay, excellent. Yerkegali and Dulat, fabulous presentation. Thank you. Yes, we do have about 10 or 15 minutes for Q&A. And with that, I'm going to turn it over to my colleague, Almas, who has been fielding questions coming in by chat from the participants. So Almas, please go ahead and read the first question.
Yes, Yerkegali, Dulat, thank you for your presentation. So we have several questions. First question is, how often should the AIFC participant companies review the effectiveness of their AML policies, procedures, systems, and controls? Is there any requirements?
At first, the review of the AMLCFT policies depend on the risks. For example, on the initial stage, of course, all the relevant persons should establish the minimum requirements of the AMLCFT rules. But in case of the ongoing business, they can face with the different levels of the risks. And of course, in case of high risks, it will need to review the AMLCFT policy depending on the conditions. And of course, as a regulatory body, we require to conduct a review of AML policy at minimum on annual basis. because on the other hand, the relevant persons have a requirement to provide an annual AML return. We indicated all the requirements of AML policy, and of course they submit its AML policies with the annual AML return. But in case of high risk, we recommend to review maybe not full AML policy, but some elements, one or more elements of AML policy review on more often time than annual basis.
Okay, thank you. The next question is from Guljan. She is compliance officer at the Quantum Capital. She is asking, AML rules includes regular audit of the effectiveness of the firm's AML procedures and controls. External audit can be conducted by compliance firms and the compliance professionals. Does it mean that external audit can be conducted by the firm's compliance officer, and will this not be a conflict of interest?
At first, in case of authorized persons, I mean authorized firms and authorized market institutions, of course, they have the internal divisions which are responsible for the internal audit. And in this case, they can conduct a review of AML policies, but in accordance with the requirement of AML CFT rules of AIFC, they define the requirements in case of external audit. And at minimum on annual basis, the relevant person should conduct the external audit, and in case of internal audit, they can also on annual basis, but in some cases can be need to conduct internal audit on the every 6 months maybe. Of course, all it is depend on the risk rating level.
The next question is from Yerlan. He is asking, do you have a separate list of extra requirements, if any, by AFSA in addition to those required by Republicans and AML law?
No, we don't have any additional requirements. All the requirements are indicated in AML rules and AML guidance. And of course, if we will have any additional requirements, we will publish on our website and inform all our relevant persons.
Okay, thank you. The next question is from Bahit. Can one person be the compliance officer for a designated business group or corporation? Can an AML officer be an external appointment?
It doesn't clear. It means two person or one person which who combine the both functions. Because in case of authorized person, I mean authorized firms and market institutions, we do not recommend to appoint one person for the both functions, because here can be the special risks in case of the combining both functions, because AML law in accordance with the requirement of AML guidance, for example, if I'm not mistaken, it's a paragraph 11, where AML law cannot combine the functions other than AML law. I mean, he or she cannot combine the operational functions, and it can include the, for example, compliance officers. Of course, the relevant person may apply for the combination of these two functions, and AFSA will consider, but we do not recommend it, because here it's high risks. And of course, here can be the conflict of interest, because, for example, when AML law acts and conduct its functions, after that, compliance officer should conduct audit and check all the functions of AML law. And in this case, how one person who combine both functions can check himself, and of course, in this case, it can be a conflict of interest.
Okay, thank you. The next question is from Adil Khan. He is asking, is there any organization where an entity can challenge AFSA decisions or inaction on AMLCFT?
Could you please clarify what do you mean challenging? I mean, maybe it's just request or maybe some disappointment doesn't understand.
Adil Khan, can I unmute you? Could you ask your question orally, please?
Hello. Thank you for the session. Can you hear me?
Yep.
Yeah. My question was, there is an action or decision of AIFC SA, and the entity it doesn't like it. And is there any organization, maybe it's a court, where this decision or inaction could be challenged? Thank you.
The AFSA decisions can be challenged at the AIFC court, that's for sure. That's the right of the participants to challenge the decision if argumented. So that's how it works. That's it.
Adil Khan, are you okay with the answer?
Yeah, thank you. Thank you. I was just wondering if there are any other ground, or is there any other place to challenge decisions?
If we are talking about the issues related to the appointment, for example, of MLRO, we have authorization committee within AFSA. You can apply or refer to the authorization committee, or if you, in general, it's general practice, if you are not happy with the, for example, financial conduct division decision or my decision, so you can refer to the AFSA CEO. That's obvious. So it's like that.
Okay, I got it. Thank you.
Thank you, Adil Khan, for your question. So there is no any questions, so I hope we can finish.
Great. Okay, Almas, thank you very much. Okay, on behalf of the AIFC Academy of Law, I'd like to sincerely thank Yerkegali and Dulat for their really outstanding, thoughtful, well-informed presentations on matters that are incredibly important to the ongoing development of the AIFC legal jurisdiction. So let's step back and just think for a minute. Let's reflect a bit about what we just learned. We really heard about the AIFC statutory regime and regulatory framework around governing certain matters that are extraordinarily important for conducting business in a transparent way that is compliant with laws and with the highest integrity. So think about what this is all about. You know, it's about AIFC setting very high international standards that builds credibility, and it's really intended for the protection of consumers, and it's really intended to supervise regulated activity so that there is always a fair playing field. These are incredibly important areas, anti-money laundering as well as counter-terrorist financing. We heard about that some of the practices include really knowing your customer. In other jurisdictions, there's an acronym, yet another acronym called KYC, know your customer. And that means that there will be some formality around business risk assessment, as well as customer due diligence. And when you think about anti-money laundering, it's not about one size fits all when conducting these analyses. There are various applications, whether it be in the securities industry, the insurance business, the financial services and banking, cryptocurrencies, even mobile payments and things like that. These are all potential landmines, if you will, for illicit practices that could serve to the detriment of consumers. So these things really matter. Thankfully, on another note, taking a new direction, we are working with AFSA, Dulat, Yerkegali, and their colleagues, along with the Academy of Law team, to put together some compliance programs, some anti-money laundering international certification programs. So please stay tuned. There will be more to come, as our focus is really developing the human capital and helping to support the development of the professional competencies that are going to be required to operate effectively in this global international business environment. So with that, thank you again, Yerkegali and Dulat. We look forward to seeing you again. And thanks so much to all of our participants today. Please join us for our future learning and development programs that we have forthcoming. Okay, thank you very much, and have a great rest of your day. Goodbye.
Thank you, David. Thank you all for the attention and the interest. Thank you.
You're welcome.